Gentlelady yields back. Gentleman from Virginia is recognized.
I thank the chairman. I thank the committee for all their work on this important issue. The Constitution is under the jurisdiction of this committee, and the Fourth Amendment is pretty clear. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. No asterisk, no footnote that says, except for this case, or in cases of, national security or otherwise. Let me just ask our Ms. Griffin, under 702, the government is prohibited from engaging in reverse targeting. Can you describe what reverse targeting is and why it's problematic?
Reverse targeting is when the government claims to be interested in the foreigner overseas, but in fact, the reason the government is collecting those communications is because they are interested in the communications of an American who may be communicating with the foreign target.
What penalties, if any, does Section 702 levy against government actors that engage in reverse targeting or otherwise abuse the FISA framework?
Well, right now there are internal accountability procedures that have been adopted by the FBI. I don't think that they're public. They were required by RISA. I don't think that they have been made public, and there's no public information. I'm not aware of anyone having been disciplined for. Do
we have an estimate of the volume of Americans' communications that have been collected as part of Section 702 surveillance?
The government has refused to provide that estimate. Members of Congress have been asking for it since 2011.
And has the FBI ever estimated the volume? To your knowledge?
Not to my knowledge. I'm not sure that they are particularly interested in
now,
that number.
As you've discussed, according to the OD&I report, queries by FBI were up to 2.9 million in 2021, 2.9 million. Declining to 119,000 in 2022, 57,000 in 2023. Between April 2024 and April 2025, down to 9,000. Can you estimate as to why there was such a large number of queries in 2021 and why that number has come down dramatically in recent years?
Yeah, what we've been told by the FBI is that there were a lot of batch queries, or perhaps even just one particularly large batch query. That's when a large number of individuals are sort of queried at the same time under the same rationale relating to a potential cybersecurity threat. It's still hard to quite figure out the math and how they got to 2.9 million with that. The argument for why the queries have come down is because there has been an effort to put more oversight in place. And I think that is, and there's been a lot more attention.
More sunlight.
Exactly, there's been a lot more attention paid, and certainly the reauthorization was coming up, and so we saw a decrease. But I would just want to remind you that that last number, 9,000, that's the number of known and counted queries. We don't know the actual total number.
All right, let me go to Mr. Scher and talk about RISA. When we passed RISA, what would you say were the most important reforms that RISA implemented?
Certainly one of the most important, I think, was the provision allowing the chairs of relevant committees in this body and in the Senate to be present in FISC proceedings and to be able to understand what's happening in that body. I don't know how you provide oversight to an institution like that unless you could at least attend its proceedings once in a while.
We're all cleared, so
right.
Would it be problematic to say, or the designee of the chairman on the committee?
That would be a wonderful addition, I think.
Help us spread the burden, wouldn't you say?
Yes.
All right. I think
and,
and
the accountability.
It's a small room, but I think there are many of us on this committee who would be willing to go down there and spend some time in there. And let me just say, as a reporting requirement of RISA, the DOJ OIG released the report which found that the reforms implemented have, quote, significantly reduced the number of non-compliant queries identified, end quote. Now, what further reforms, I mean, to reduce this number of non-compliant queries down to 0, is a warrant requirement necessary?
I think so. And even with a warrant, there will still be some mistakes made by the courts, but the number's going to go down very substantially if you have an independent judge looking at these requests.
Thank you.